Section 117A to provide exceptional circumstances under which persons not otherwise subject to military law may be tried in the court-martial. And this is in compliance with the advisory order that was given the Supreme Court judgment on page 199 of the judgment. Section 117D on page 46 prescribes specific offenses that bring a person who aids and abets under the jurisdiction of the court-martial, and also introduces the element of conspiration. These offenses, they are murder, aggravated robbery, kidnap with intent to murder, cattle rustling, treason, and misprision of treason. Section 117A, E to F, on page 46. It introduces Schedules 7A and 7B specifying arms, ammunitions, or equipments ordinarily the monopoly of the defense forces, and classified stores. And for ease of reference, 7A is at page 73 of the bill, and then 7B is at page 76. Clause 35 on page 49 introduces section 192 to establish the unit court-martial in each unit of the defense forces, its compositions, qualifications of chairperson, who should be a holder of a bachelor's degree in law and a diploma in legal practice. It also provides for the jurisdiction of the court to try offenses whose sentence do not exceed 5 years. It also provides for an appeal from a unit court-martial to lie to the general court-martial. And the composition is the chairperson and 2 other members. And when there is a matter of law, the decision of the chairperson is final. Clause 36 on page 52 to 53 introduces section 196, which establishes a division court-martial in each division or equivalent formation chaired by an advocate of the High Court, who will be appointed in consultation with the Judicial Service Commission. It provides for the composition and qualification and the division court-martial also have jurisdiction to try an offense under this act or under any other written law other than an offense in respect of which the maximum penalty is death. The same clause provides for appeals from division court-martial to the general court-martial. Clause 38 on page 54 introduces section 195 to establish the general court-martial, which shall be headed by a person qualified to be appointed the judge of the High Court and who shall not be below the rank of Brigadier General. 2 members who shall be advocates of the High Court and not below the rank of Colonel. 2 senior officers who shall be advocates of the High Court and such other advocates as may be determined by the High Command. The quorum of the General Court-Martial also is by 3 members, the chairperson and 2 other members. And the same clause provides for a panel. It provides for panels at the General Court-Martial so that at different times we can have different panels sitting at the same time. Clause 38.2 on page 54, members of the General Court-Martial shall be appointed by the High Command in consultation with the Judicial Service Commission. Clause 38.5 on page 55, it grants the General Court-Martial original and limited jurisdiction to try any offense under this Act and any other written law by persons subject to military law. The same clause 38.14 on page 56 also provides for appeals from the General Court Martial to the Court of Appeal of Uganda. In compliance to the Supreme Court ruling, Honorable Chair, clause 45 is also introduced on page 57 to bring in the following. Section 202A on page 57, which provides for the judicial oath to be taken by members of the court martial, Shed 6A at page 72, and this is the same as that in the Constitution at page 233. Section 202B on page 57, which establishes a military court department appointed by the High Command, which shall be responsible for the administration of justice within the defense forces. Section 202C at page 58 provides for independence and impartiality of the court martial. Section 202D on page 58 establishes a disciplinary committee responsible for the discipline of the members of the Military Courts Department and its appointment in consultation with the Judicial Service Commission. And the committee is composed of a chairperson who shall be qualified to be a judge of the High Court and 2 other members who shall be advocates of the High Court. And clause 63 on page 63 introduces section 233.2 to provide for appeals from General Court Martial to the Court of Appeal of Uganda. Those are the amendments to comply with the Supreme Court ruling that have been captured to enable the court martials conform with the Supreme Court decision.
Thank you. Honorable Chair and honorable colleagues, for the first time in the history of this country, based on the judgment of the Supreme Court in the appointment of, in the composition of members of the court martial. So that has never happened. That brings the civility in the process of administering justice in the military courts martial. To us, based with the advice of the Attorney General, who did a lot of research, we compromise on that one. That now, in the appointment, we shall do it in consultation with the Judicial Service Commission. If I was saying this somewhere else, I would have asked for the applause. But now, since I'm in the Committee of Parliament, everyone is looking at me as if I have not said anything sensible. I want to thank you, and that marks the end of the presentation of the bill, and I want to lay the copy of certificate of financial implication, which I know that.
It is worth noting that since 2005, the defense sector has undergone significant transformation arising from both emerging threats and opportunities. Several of them were unforeseen and not adequately addressed by the Act. The main object of the bill, therefore, is to amend the Act to align the provisions of the Act with the emerging issues in the defense sector, in particular, aligning the Act with the new government policies and the command, control, and other administrative structures of the Uganda People's Defense Forces, which have evolved by virtue of the introduction of new services in the defense forces. Further, the bill seeks to align the provisions of the Act with the Supreme Court decision in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael Kiwanuka. 1. The scope of the bill in light of the Supreme Court decision, right honorable colleagues, is 1. The bill seeks to restructure and establish the courts martial in the defense forces in accordance with Article 129 1D of the Constitution and prescribe their jurisdiction, to provide for its membership and qualification of the presiding officers of the courts martial, and for the independence of the courts martial. In particular, Clause 35 of the bill provides for the amendment of Section 192 of the Principal Act. Clause 36 provides for the amendment of Section 193 of the Principal Act, and Clause 38 provides for the amendment of Article 195 of the Constitution. Honorable colleagues and members, Clauses 39 to 44 and 46 to 75, I've not mentioned them here, are consequential amendments as a result of this, and these mainly relate to the provisions that are being repealed. The establishment of the divisions court-martial and the general court-martial. The bill in particular clauses address the issues of the composition of the courts-martial, the appointment of the members of the courts-martial, the jurisdiction of the courts-martial, the qualification of members of the courts-martial, the tenure of members of the courts-martial, the quorum of the courts-martial, and appeals. The bill also seeks to prescribe exceptional circumstances under which civilians may be tried by the courts-martial. It is worth noting that 6 out of the 7 justices of the Supreme Court in their decision found that Section 1171G and H of the Act that provides for trial of civilians in courts-martial were unconstitutional due to vagueness. Further, 6 justices noted that for a civilian to be tried in the courts-martial, there needs to be in place clear exceptional circumstances. In light of the above, Clause 30 of the bill seeks to prescribe exceptional circumstances by inserting Section 117A. The exceptional circumstances include: 1. Where a person voluntarily accompanies any unit or other element of the defense forces which is in active service in any place. 2. Where the person, while serving with the defense forces under engagement by which he or she has agreed to be subject of military law. C. Where the person is in unlawful possession of arms, ammunition, or equipment ordinarily being the monopoly of the defense forces as prescribed in Schedule 7A of this Act, or classified stores as prescribed in Schedule 7B of the bill, and commits an offense under any written law. D. Where the person aids and abets a person subject to military law in the commission of or conspires with a person subject to military law to commit murder, aggravated robbery, kidnap with intent to murder, treason, misprision of treason, and cattle rustling. E. Where the person without authority is found in possession of, sells or wears a uniform, the correction there should be SELLS, sells or wears a uniform of the defense forces. F. Where a person is found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the defense forces prescribed in Schedule 7A of the Act and classified stores in Schedule B of the Act. Where a person is serving in the position of an officer or militant of any force raised and maintained outside and commanded by an officer of the defense forces. Honorable Chair and colleagues, the bill under Clause 45, insertions of Section 202A, 202B, 202C, and 202D, seeks to reinforce the independence of the courts-martial and the defense forces. Sections 202A, which is proposed to be included, provides for the members of the court-martial to take the judicial oath. 202B provides for the establishment of military courts department, which shall be responsible for the administration of justice within the defense forces and provides for its membership. 202C provides that members of the courts-martial shall, in the performance of judicial functions, be independent and impartial and shall not be subject to command. And 202D provides for the establishment of a disciplinary committee for members of the courts-martial. The committee shall be established by the High Command in consultation with the Judicial Service Commission. It is important to note that in order to provide for independence of the members of the courts-martial, the bill proposes A, to have the members of the General of the General Court Martial appointed by the High Command from a list approved by the High Command in consultation with the Judicial Service Commission, and to have the chairperson of the Unit's Court Martial and the Division Court Martial appointed by the High Command in consultation with the Judicial Service Commission. Stakeholder engagement. The Ministry of Justice and Constitutional Affairs drafted the Uganda People's Forces Amendment Bill in consultation with the Ministry of Defense and Veteran Affairs in accordance with the instructions received from the Ministry of Defense and Veterans Affairs and the approval of Cabinet. Regional and international alignment. It is worth noting that sections 38, 39, clauses 38, 39, and 40 of the proposed bill, which provide for the deployment of troops outside Uganda, provide for the Uganda People's Forces international and regional security commitments adequately. The provisions have not been amended in this bill. Honorable Chairperson, honorable members, I beg to submit. I thank you.
Which means of all these coups, there have been a lot of hands being deposited in community. Comrade, there is need to make people fear these guns. There's a greater need to make people fear to use these guns anyhow. No matter I'm here, first and foremost, being from Karamoja, where there are illegal guns, there are guns in the hands of people who are neither soldiers, you don't understand them, but they are armed to the teeth. I could be the one opposing this bill, but I've come here to support the bill, to say, no, look, some of these people must be dealt with. I want to give an example in my constituency. In the last 6 years, people who have been killed with the people who have guns, who are not soldiers, are 3,985. 3,985 people, we have lost them. Police, the best they can do is to do post-mortem report. So far, we have a police station where there's a room full of post-mortem reports only for 3,980. Not even one person has been prosecuted. There could be challenges in any law. As we talk, comrade, we could be having other, people have a lot of views. There could be flaws, there could be others. But in particular, these laws are very, very vital. For example, to answer the Karamoja question, so far stability is there in Karamoja because through the court martial, most of the criminals are in prison, which has now been done under the normal law. So I would think that, comrade, in good spirit, in order for peace to be in this country, and for some time, unforeseeable, we are not saying the law will be there forever. If this country improves, we shall keep on reviewing this law. But where we are operating currently, ladies and gentlemen, like us from Karamoja, we need to think about us. As we look here, this country are different. Karamoja is a different question. Without the court martial, there could be a different story now in Karamoja. But because of the action that the army took using the court martial, we are seeing peace. We are about to join development. We are about to join the rest of this country in contributing for progress in this country. So I would know people have different reservations about the law. Let us look at how to handle the excesses if at all they are there. But the law in principle is we need it at this point in time. So, Mr. Chair, I am here submitted that. For me, I think I'm comfortable on the special circumstances in my legal mind. The special circumstances are very critical in ensuring we govern. Because if we allow people to even use to manipulate UPDF, if we allow people to manipulate UPDF to their will and they walk away, this is dangerous. It's good we put them in the hook so that everybody fears to go near the gun. Because the gun has been misused in this country. Some of these laws are based on our history as a country. So, Mr. Chair, I strongly support that we committee recommend this law to Parliament. We put this law in place, such that the army are governed. These soldiers, comrades, look at them also. We need to govern them. Otherwise, comrades, things can be a bit very difficult. Even in election, they can manipulate elections and lose elections. So we better have the court martial to keep them at bay. Otherwise, I first end there, Mr. Chair.
Kiwanuka is saying that we must make it extremely risky.
Mr. Chair, you ably communicated that the concerns of the public, save for all the rest of the good about the bill, the issue of civilian. In my line of work as a spokesperson, and sometimes I want to speak from the sense of knowledge and understanding, somebody will pop a question. Now, when you look at the categories of people, you say aid, how do you get the certification that this person is aiding? And then we have murder, aggravated robbery, kidnap, but we have competent courts as well. This morning, I was having a discussion with someone, and he asked me, look here, we had a rebel leader, General, I don't know the rank, whether he was entitled to any rank, Jamil Mukulu. And we have this court, the Criminal Division Court. And this man was never subjected to the General Court Martial. But you're saying where we have courts, civilian courts, that are trying people of murder, aggravated robbery, but now you're saying they should. Why don't we look at strongly empowering these courts? Because, Mr. Chair, the bill is extremely beautiful. And if this bill was speaking to a young girl, the girl would only accept to go for marriage. But there is that hiccup that we need this legal mind. How do you justify? But we still have these courts. Are we now disempowering the civilian courts? Are we really looking at that only clause to justify that the civilians? I was talking to Jonathan here. We know some people hold guns, lawfully trained, private firearms. But then how would that justification be? So, Bwana Attorney General, we need really to know so that we really speak to this. We need peace, we need to be protected, we appreciate, but we still have courts that are really competent enough to handle this. As we do, let us reflect onto that. Thank you, Mr. Chair.
The Army for improving the welfare of the officers and the militants, for decentralizing the pension authority, enhancing the compensation and fair payment in case of injuries, and to, I think, those ones, which I think goes a long way in addressing the concerns that existed within the country and complaints that come from the Army. I am particularly interested in how the gaps in the payment, the salary structures will be addressed, which is one of the concerns raised here. Mr. Chairman, I have a number of concerns. The first is that one of the justifications for this bill is stated to be to align the Act, the UPDF Act, with the decision of the Supreme Court. My question is, what was the issue before the Supreme Court and what was the decision? Which I will also attempt to answer. The question was, is it lawful? Is it legal? Is it constitutional to try a civilian in the military justice system or military court? That was the only question that went to the Supreme Court. And the answer was, it is unconstitutional, it is illegal. I want the movers to show me in this bill how you have complied with the decision. There was one decision that it is unconstitutional. Do not try civilians before the court martial. I want to find out where in this bill you have aligned that question, which was answered by majority unanimously, so that I can trace it. So far, I have failed to see it. The mover seemed to have gone and created his own judgment, his own decision, his own orders, and then it is being used here. I would be very happy if that is pointed to me. And I could have even stopped at only that. But let me go to the others to help me. It is stated,
Interjection from the
it
minister.
is stated, you will clarify.
There's some
You know,
interjection.
I wanted to interject.
No, to just help us know that we are reading the same bringing. that we could have set up our own judgment. Can you refer us to the page of the judgment that you are referring to, so that we look at it that we are referring to the same thing?
I will refer was first before the Constitutional Court, and the Constitutional Court agreed with the petitioner at that time and said it is unconstitutional. The learned Attorney General appealed on the question of constitutionality of trying civilians before the court-martial when it went to court. And you have quoted it here. It is in the Supreme Court Constitutional Appeal number 02 of 2021, Attorney General versus Michael K. And for me, I am just saying, you will answer.
We just needed just guidance, because if you helped us, it could help us to think, because if you point us to the part of the judgment that you're referring to, it will help us to understand what you're, that's the concern.
When you presented here, citing different, did you tell us the paragraph and the pages? I'm following from you, because you say you were presenting, because we read, you presented here, there is no single paragraph of the decision that you have referred to. I can refer to your presentation, the learned Attorney General.
So, okay, so you want us to provide you the provision?
I will not do for you your job.
Okay.
Yes.
Thank you. So we are happy to.
Thanks. Yeah, and thank you, Chair. The second issue that I would like is that the justification further says this bill, some provisions, some sections of it are in compliance of the orders. You have also said recommendations. It has been used interchangeably, orders and recommendations. I want you to show to the full extent, not isolating one or two orders, how you have complied, how this bill complies entirely with those orders and recommendations, without isolating others. Maybe at some point you will now read to us the list of those orders one by one and how the order has been implemented. The other issue that is necessary for me to examine the certificate of financial implication. You state that there is lack of differentiation in the existing pay structure of the UPDF based on rank, and which has resulted in uneven pay for military personnel. Can the mover convince us and demonstrate the unevenness in the payment and the differentiation, and how much is required, providing the full details so that we can arrive at the figures stated or projected in the certificate of financial implication. I would also like to know, because bullet 2 of the PowerPoint presentation talks of addressing the welfare of veterans through the different mechanisms, which is very important, as the veterans have been complaining time and again. I would like to know specifically the figures attached to this. And Chair, the reason why I'm raising this is that we have not yet concluded the budgeting process. And I know next year there will be budgeting process. We do not want to reach a point where we have provided for in the law and then the same government executive appears and tells us there is no money to enhance. Because from this, there is enhancement spread all over in pensions and gratuity and etc. So we would like to know the figures attached there. I am not yet done. Yes, thank you. Of the forces, the two exist, and they are called the Land Force and the Air Force. We want to add two more, the Reserve Force and the Special Force. Of the four, only one is given the word command. The rest, Land Force, Air Force, Reserve Force. But this one is said special force command, I am not subject to military law. The use of the word command in law, is it creating a superior force over and above the rest? Because if I am the one special force command, and I just want to understand whether that is the spirit, so that when I'm making a law, I can explain that there is now a superior called special force command, and yet the others are command, or it is to call it a special force and then remove the command. That is my concern, the use of the word command, not on the speciality it is. It can be special in other ways, and that can work. There is a question throughout what we call service offense. I don't want to go to offense. In your understanding, what is a service in the defense forces? What is a service? And I'm heading now to the issue of trial of the civilians. I have looked through other sections. You have stated that if I get injured, there are now calculations on how I should be paid 100%. You also seek to conscript a civilian for purpose of trial, if it passes, to be a militant, meaning with a force number and etc. So let's give the example of live cases that are happening. And I'm not saying it is true or it is not. The allegation in some of these is that there are a group of people who were involved in aggravated robbery, and they are being tried in Masaka with the one Eddie Mutwe and the rest. I presume if this law was in force, you would give him a militant or a force number, and then you try him. And I want to believe that the military court-martial can convict or also acquit, because it is a court, it can do either. After acquitting him, with all the torture injuries, is he qualified to be compensated? Because he's now a militant. That you now compensate him in that process. That's the question of law that should be answered. Minister, you take time, don't be discomforted by this. It's just a practical question. It can happen to all of us. In fact, can happen to you as well. The question is, a civilian is accused, and the allegation that you have committed murder, the offenses you have listed under the Act. For purpose of this trial, you are proposing he or she will be assigned a rank or considered a militant if it does not have a higher something like that. Because for you to be tried for a service offense, you must be in the service. That's my interpretation. You must be in the service. So if the end result of that trial process is that I am acquitted, and I am saying this because I believe that the court can convict, can also acquit. I don't know, maybe the judge advocate could tell us how many trials has led to convictions and how many has led to acquittal. But now, because of that, I am now part and parcel of your structure. I now choose to continue being a soldier after acquittal. Will you even continue with me? That's the first question. Then the injuries that occurs to me in the process of being considered a militant, and there is a provision for this act for compensation. Am I also now entitled to compensation because I have militant? How do I retire my rank as a corporal that you assigned to me, or how do I retire now from the military service? It's a question that I think you could help us answer. When we go to exceptional circumstance, who determines the exceptional circumstance? Because the offenses here are triable. If the act passes through, there is a choice to try it in the civilian jurisdiction, the courts of judicature, the ones we know, High Court, Criminal Division, but you also want to try, the choice to try in the court-martial. So if I contest that there is no exceptional circumstance, who? Is it the civilian courts first to look at it and say, we don't have, this is an exceptional circumstance, I agree, so you go? Or if I prove to the military court that I am not under the purview of the exceptional circumstance, do you then send me to the civilian court? What happens there if there is contestation over the definition of exceptional circumstance? I want to now end and share you. These are the things that if we had harmonized. Now, the question on independence and impartiality was cited by the Supreme Court. In arriving at that decision, which is, it is unconstitutional to try a civilian, they had examined this. And the question of independence and impartiality was not addressed in terms of taking judicial oath, in terms of qualification. It was built on the cornerstone of our democracy, the triangle, that an accuser cannot be the one bringing, because all criminal cases are brought in the name of the state. And the state is controlled by the executive. So if it is the executive making this complaint, and then it's the same executive which has enforcement control over the army, is the one going to accuse and prosecute and judge. That is the purview under which the Supreme Court and actually Court of Appeal said it is unconstitutional. So the independence and the impartiality is not in taking judicial oath. It is not in asking Judicial Service Commission to consult them, not even with a recommendation. Your use of the word here is to consult, which is different from the practice of what is happening with our judges. It is recommendation, but here you are saying consultation. So how can the one in control of, I can even use the word, if I don't know, you will help me, when Dr. Besigye was acquitted, I think by one of the judges, he used some words. How can somebody in charge of concocting cases, fabricating charges, manufacturing evidence, and then be the one then to judge? Because the total chain is controlled by them. From the accusation to the assembling of the arsenal for persecution and prosecution, it is the same person. How can I then be sure that that person is going to decide in my favor? That is the question, on the basis of which the Supreme Court said no. Because the control of the three arms of government is well known to you, learned Attorney General. I still have many chairs, so I don't know. I see you're impatient.
First, take a break. The Honorable Jonathan Odur is the Shadow Minister for Justice and Constitutional Affairs.
Okay.
And first, take a break.
Okay.
Let the Attorney General first ponder.
Specifically, from the side of my neighbor here. And I decided deliberately to sit next to him for us to agree that let's allow the court-martial to be there. An army officer only fears an organ in the army called a court-martial. That's the only one. The moment you don't have a court-martial, then there would be no army. It will be a ragtag army. That anybody can make a decision on his own. So we need discipline on possession of a gun. I know most of us hold probably pistols, and we fear that the repercussion would be if you commit an offense or if you are implicated, you may be taken to a court-martial. But a court-martial has people who use blood, and they can be able to decide whether the judgment or the case is right or wrong. Mr. Chairman, I would like to make some few observations, and specifically on the principal law and also the bill itself. The omissions on the principal law were on, one, providing definitions on the interpretation clause, number one, definition on arms. I think, Attorney General, you need to note it. Then you will provide the definition. Number 2, definition on ammunition. Number 3, a definition on military uniform. Number 4, a definition on military stores. Stores, of course, will lead you to the expendables, dry ratio, POL, which is petroleum, oil, and lubricants, arms and ammunition as well, including also clothing that include boots, uniform, mattresses, ponchos, and the rest. Another definition that needs to be captured is what has been brought up in the law, in the bill, classified stores. Then, I would like also to interest you that now we have concentrated so much on the arms and ammunition, and now we have brought in the issue of clothing. Now, why don't we look at the issue of the dry ratio? Tinned beef, tinned beans, and biscuits. Now, and this has to have again markings in it that the tinned beef is UPDF and the tinned beans is also UPDF, branded as UPDF. So the packaging must be very important, so that you don't only look at the gun, but look at also the dry ratio that facilitates the process of course, killing. Now, again, let's look at the question of the authority to use the arm, the firearm. Two soldiers somewhere were making an argument. One was telling the other one that the gun that you are using, that you are carrying, can be authorized for use by any other commanding officer. And the soldier meant the AK-47. This other one now said, me, I operate 155 millimeter gun, and the authority comes from Commander-in-Chief. Now, can we look at, again, capturing the operation or the command on use of these firearms? At what level should the firearm be authorized by a commanding officer? Because we know very well that some of these firearms at higher millimeter and caliber must be authorized by probably the command or the commander-in-chief. Now, and that is only said, but not captured in the law. Now, when it comes to the question of what I talked of, arms and ammunition, you have really attempted to bring forth some of them. But let me tell you one thing, arms are in thousands. And if we are to list them, we will need several pages, thousands of pages, in order to capture the caliber, including also the ammunitions. According to the list, of course, the South Korean made is not captured. What about the North Korean made in terms of arms and ammunition? What about the Russian made? What about the Japanese made? But we have attempted to mention it. Probably we would include the clause and others as well. Because if you look at also the emblazers, like the landmines, then there are several of them that are supposed also to be listed, and there are many. So, including also probably the Sukhois and all that has its own caliber of ammunition that it uses. So, we need to be specific so that we don't leave others outside the schedules. Because at the end we will make a mistake and somebody would be carrying a certain caliber of ammunition, then tells you, but it is not captured in one of your clauses, in the schedules. So we have to be very clear with that.
Thank you,
Honorable Minister. So on the question of the uniforms, let me finalize with the uniform.
Okay.
We have attempted to bring forth the issues of the uniforms, and we have captured it in the law that these are the uniforms that we have. Let's take this scenario. The enemy in the battlefield has already acquired the type of uniforms that is being worn by the military forces. And they are the same. What would be the strategy? The strategy is to go back and change the uniform to another color that the enemy doesn't have. Now, and we have entrenched it in the law. How do you really change that immediately? Yes. So probably you will also provide maybe a clause to align that and align the changes that can be made on the field. Thank you so much.
Honorable Keyo.
Thank you, Chair. Actually subjected to unit court martial. I want to know from the Minister and the Land Attorney that actually it addresses comprehensively, but I find it too much, addressing too much issues in one bill. Secondly, Honorable Chair, I want to know, because the bill says that it prescribes the qualification of the chairperson, the presiding officer. How about the vice? And in case, and then leaves others hanging. It is only the presiding officer whose qualification is defined. In case he is away or she is away or absent, don't you think the vice is not qualified enough if it doesn't address either the chair and the vice shall be of either qualification to be high court judges? I want that one to be addressed. Then also, I think when he was presenting, he stated that actually there will be panels to address this. General court martial shall have panels, and there is only one qualified person who will preside over these other panels. Yet it is only the chair or the presiding officer qualified to preside over the court martial. And then also, I think Honorable Dur also hinted on it. Why don't we leave the Judicial Service Commission to do it in consultation with the Minister of Defense instead of vice versa? Because we know in civilian courts or courts of judicature, it is always the Judicial Service and then eventually the President appoints. I wanted the clarity on that. And then what would be wrong to say Land Forces Command, Air Force Command, and not only Special Force Command? And then that one, we need the law should be clear. The law should be clear. We are making a law, and the law should not have any gaps that can be exploited. And then exceptional cases. Who really will determine exceptional cases? Apart from saying the crimes in exceptional cases are this and this and this, who will determine that actually now here you are supposed to not to go to court martial and go to the courts of judicature? Thank you, Chair.
Honorable Nambos.
That's to be very cognizant of the court ruling, Supreme Court ruling. The Supreme Court ruling states that civilians should not be tried in court martial. They say civilians. Now here you are saying under certain circumstances, exceptional, civilians should be tried in court martial. Now I wanted to know what has changed that the court martial has been doing with the civilians in trying them in court martial, now that they seek to change and try them. Because here, principally, the ruling says civilians, not exceptional, civilians. So there it causes an ambiguity. Attorney General, you will need to give us a better statement whether this one may not contravene the Constitution especially Article 92 about the activities of Parliament versus the court. So we need that. Finally, the issue is on uniform. I have seen here you are stating the shoes for military, black shoes for ceremonial shoes for the military. It is almost the shoes I'm wearing. It means all now shoes in Uganda, when they are black, will be police of military. Meaning all Ugandans may end there. It is here, the picture is here. Honorable Minister, don't intimidate us, I'm giving a submission. You will also clarify, because the picture is here showing picture 25. This is a normal shoe for all Ugandans, all members of parliament are wearing now here. So meaning all of us, we may end in the court martial unless if this is changing. Maybe yes, even the minister is putting on the same shoes. So you may end up, you may think you may be the first person to be paraded before the court martial because of these shoes you are showing. So we need clarity so that we don't pass a bill tomorrow, then we come here, we need to change. There is a lot we need to change here. Thank you, Mr. Chairman. You may end up.
Yes, Mpuga.
Yes, it even affected the Land Attorney General in trying to bully the Honorable Jonathan, but I'm happy that is now under your full control. So allow me to make very humble submissions. You see how he's looking at me? Yeah, he's even pointing at me. So you'll have to protect us from the arch-bully in the minister, that we do our job well. My shoes are brown, please, and they don't have the shape of...
to look at me and not the members submitting. Is that possible, isn't it?
Yeah, let him look at you, and I will
You should smile.
Honorable Chair, I have a few issues to bring to the attention of both the Minister and the Land Attorney General. I went through this bill over last evening and this morning, trying to find where to press the new provisions in line with the command of Article 129D. I have tried to establish, with all the voluminous presentations, how then you have the court martial becoming a court. I can't find it, save for the words here enshrined. I was trying to close them into the law as known. Would the Land Attorney General advise me how these amendments fall within Article 129(1), so that eventually we can see the court martial becoming a court? Because the ruling, Supreme Court ruling, which has been deemed as advisory and therefore motivating over these amendments, was very clear on what makes a court. And it's not merely personnel, it must also be existing within the law, and the law is Article 129. I want the Land Attorney to help me place these amendments. Because I'll give you an example, Honorable Chair and colleagues. When the ICD was being formed as a branch of the High Court, the International Criminal Court, Criminal Division of the High Court, clearly the parameters that formed it were clearly under Article 129 and was deemed the High Court. The amendment so provided by the Land Attorney General and the Minister, for me, still contradict what the Supreme Court actually guided about. And at no one time did I envisage the ruling as advising the military or the minister to go and try to be creative and even try to strip civilians of their status and bring them in under the ambit of the military to sort that ruling. It never was the objective, because we need to understand, Honorable Chair, the ruling of the Supreme Court is almost enacted law. It never at any one time empower government to go and strip civilians of their status for the sake of conveniently trying them in the military courts. That was not the objective. The objective was strengthen Article 28, which talks about a fair hearing. That's why throughout the thread of this ruling, there is reference to Article 28, 1, I think, D, and Article 44C. None of these amendments, and I'm here to wait to be convinced, speaks about that when you have these amendments, therefore you'll have a fair hearing. Therefore you'll have a speedy trial. You'll have, fair presentation. Honorable Chair, I want to be convinced that these amendments actually speak to the command of Article 28 and 44C. Otherwise, taking them on face value would mean that the UPDF Act is now the supreme law of the land and the Constitution is subordinate to the UPDF Act. Honorable Chair, the exceptional circumstances and whereas the ruling spoke about the fact that all these cases referred to as exceptional circumstances can be tried in civilian courts, and indeed they can be tried in the civilian courts. I have not seen these amendments speak to the fact that the civilian courts are inadequate in trying these matters, and therefore the warranty being taken to the court-martial. These amendments are not stripping over that fact and are not introducing anything new to warranty exceptional circumstances. Right, Honorable Chair, the lawyer in you, the advocate in you knows so well that murder, cat rustling, and all these cases can be ably tried in High Court and the entire apparent system of the courts of record. So where is this coming from? Isn't the minister trying to impute ill motive on the part of the Supreme Court in using their ruling to say they were given room to override the Constitution in bringing these amendments? Because I have been carefully trying to see where is the gap, where is that lacuna they're trying to cure. I cannot trace it. So, Honorable Chair, for me, I am not sentimental, I'm not emotional. I am tracing for what the Constitution says, and where the Constitution commands, I am obliged to obey. I am failing, and I'm failing to see a single clause that makes the court-martial a court throughout these proposals. Not improving the personnel to say, as long as the personnel is, the chairperson is an advocate of the High Court, that cannot turn it into a court. Otherwise, I'll sit here and turn you into a court because you're an advocate, so am I, so several others. With Mr. Kiwanuka, yourself, Senior Abdul Katuntu, and you say, as long as Katuntu has served for 25 years, he also is now a justice of the Court of Appeal, who become part of. So it's not a question of qualification. It's not a question of service. It's a question of the Constitution, Honorable Chair. I am waiting. That single statement here that confirms that these amendments have changed the command of the Constitution in what is a court. Thank you.